A very warm welcome to all. Today, I, KHANNA, a legal intern under LEXIS and Company, am here to explain my topic, Role of Judiciary in Promoting ADR. India is a country enriched with abundant natural resources and an enviable demographic dividend, wanting only in availability of capital to propel the country on a path of unbridled economic growth. To attract investors from around the globe, it is imperative to promote ease of doing business, of which the judicial mechanism on settlement of dispute plays a vital role. To take care of that, arbitration has been introduced in the Indian legislative judicial system. Although the provisions on the same have been around since 1940, it is in the recent years that commercial arbitration has received increased impetus to ensure that the disputes are resolved in a time bound manner aimed at reaching a decision that pays heed to the economic and judicial interests of the parties involved. Let us understand, what does ADR mean? ADR in full form means alternate dispute resolution. Alternate dispute resolution, as the name suggests, moves away from the traditional court system and is hence an attempt to devise machinery capable of providing an alternative to the conventional methods of resolving disputes. ADR offers to resolve matters of litigants whether in business causes or otherwise, who are not able to start any process of negotiation and reach any settlement. The ADR mechanism takes into account that the court-based dispute settlement mechanism is expensive and time-consuming, whereas this opens a need for an alternative mechanism that would make the process simpler and address these concerns. The use of ADR as a tool to reduce the backlog of cases in India through arbitration, mediation, and conciliation. Lok Adalats and Gram Nyayalas and Nyaya Panchayats are the contribution of India to the jurisprudence of ADR. This concept covers a number of methods of dispute resolution which fall into two broad categories: court annexed options and community based dispute resolution mechanisms. Court annexed ADR includes mediation and conciliation, where a neutral third party assists disputants in reaching a mutually acceptable solution. Supporters argue that such methods decrease the cost and time of litigation, improve the access to justice, and reduce court backlog, while at the same time preserving important social relationships for disputants. Community-based ADR is often designed to be independent of a formal court system that may be biased, expensive, distant, or otherwise inaccessible to a population. These include arbitration and negotiations. Let us understand the background of ADR in India. As a as the time passed, it was realized that our traditional court system became outdated and there was need for another mechanism which supports our judicial system as a substitute or alternate in settlement of dispute of people. Some drawbacks with our judicial system are overburdened court, time consuming, expensive, technical process, low ratio of judges to population, unfilled vacancies, long procedural pendency of cases. So, about 40 years ago, late Mr. M.C. Setalvad, the first General of India, addressed the Bar Association of India and said, I quote, "No doubt the British system of administration was very good and led to excellent results. But it had its defects, which have been accentuated in two ways. We are now a democratic and a very populous country. In these days, therefore, what is required is a radical change in the method of administration of justice. We want the courts to which people can go with ease and with as little cost as possible. It is not merely the quickness of justice, but it is the easy approach and quick disposal, both of which are needed, and that can be only achieved if the system is completely overhauled." Further, Justice R.C. Lahoti also observed that working under considerable handicaps, such as inadequate funds, budgetary allocations for law and justice, not being part of planned expenditure, lack of resources, shortage of staff and infrastructure, and the Indian judiciary can still claim a better standing with the other wings of governance in performance. The first step in the advent of ADR mechanism in India was taken way back in 1940 when the first Arbitration Act was passed, but due to its inadequacy and loopholes, it was never fully implemented. Many years later, in 1996, the Arbitration and Conciliation Act was passed, which was based on the UNCITRAL model, where the Section 30 encourages the arbitrators, with the agreement of the parties, to use mediation, conciliation, or other procedures at any time during arbitration proceedings to encourage the settlement. The Legal Service Authorities Act 1987 brought about the establishment of Lok Adalat system for settlement of disputes cheaply and expeditiously, and also in the spirit of compromise by give and take formula. Further, Section 89 of the Civil Procedure Code 1908, which is based on the recommendations made by the Law Commission of India and the Malimat Committee, made it obligatory for the court to refer the dispute after issues are framed for settlement with the concurrence of parties by any ADR mechanism. When the parties fail to get the dispute settled through any of the ADR methods, then the suit would come back to the court and it was filled in. While the Lok Adalats are a concept that has flourished in both rural and urban settings alike, when it comes to other mechanisms of ADR, the only field where the courts in India have recognized the same is in the field of arbitration. The court's keen to see whether the arbitrator can exceed his jurisdiction while deciding the issue which has been referred to him for arbitration. The scope of interference of the award passed by an arbitration was dealt by the apex court in the case of Food Corporation of India versus Joginder Lal Mohinder Pal in All India Record 1989, where the apex court stated, I quote, "It is the function of the court of law to oversee that the arbitrator acts within the norms of the justice. Once they do so and the award is clear, just and fair, the court should, as far as possible, give effect to the award of the parties and make the parties compelled to adhere to and obey the decision of the chosen adjudicator." It is in this perspective that one should view the scope and limit of corrections by the court of an award made by the arbitrator, unquote. So that is all for this particular video. In the next video, the part 2 video of this topic, role of judiciary in promoting ADR, we shall be understanding more detail the contribution of alternative dispute resolution in the administrative of justice through certain case laws, and shall be concluding the video. Thank you so much.